David, you and I do disagree on a lot of things, but I still, respect you at the end of the day. I still consider you a person that I know, a friend. But when we're going to head, it's like a basketball game. I want to win. There's no holding back. I'm going to play as hard as I can. But you can do that civilly and not have all the heated information, association, all of that happens quite often.
I'm attorney Dave Craig, managing partner and one of the founders of the law firm of Craig, Kelley Faultless. I've represented people who have been seriously injured or who have had a family member killed in a semi or other big truck wreck for over 30 years. Following the wreck, their lives are chaos. Often they don't even know enough about the process to ask the right questions. It is my goal to empower you by providing you with the information you need to protect yourself and your family. In each and every episode, I will interview top experts and professionals that are involved in truck wreck cases. This is After the Crash. Today we have Mark Metzger as our guest. Mark is an attorney and has been practicing for over 35 years. He's a founding partner of Metzger and Roska, a law firm up in Noblesville, headquartered up in Noblesville. Mark is a trial lawyer, which not everybody can say that. Mark has tried over 120 cases to jury verdict as lead counsel. He does both plaintiff and defense. He mainly does insurance defense work. He does litigation, but he also does personal injury. So he has a unique perspective because he's been on both sides, both plaintiff, the person who's injured, and defense, working for the defendants who've been sued or their insurance company. He's also a mediator. He also does arbitration, and he also teaches. So, Mark, welcome to the podcast.
Thank you, David.
So, I guess let's start off with just telling me, what do you think the difference between, since you've done both, and our audience is mainly non-attorneys, what do you think the difference is as an attorney representing the victims of a crash versus representing the insurance company, if there is a difference?
Yeah, I think the burden of proof is the difference because as the plaintiff, you have the burden of proof with regard to liability and damages. Defense, we really don't have to prove anything. We just throw up as much as we can, to talk about the liability issues or talk about the damage issues. So I think the burden of proof is really the biggest issue that separates the two.
How about like contact? I mean, so normally, I've never done defense work. I've always done injury. I represent victims of injury cases. And, oftentimes, especially on the front end of a case, there's medical bills. They're worried about wages or working and stuff like that. And so there's a lot of client contact in the beginning. I would imagine on the defense, there's probably less of that.
Yeah, that really depends upon how quickly the case goes to suit. Because once it goes to suit, then it'll be referred. I do some pre-suit litigation, but not a lot. I would say the more is matters that are already in litigation. And then we reach out immediately to any new clients and discuss the case with them. But a lot of times, again, I think a plaintiff has the opportunity to be proactive, where a defense attorney is a lot reactive. Not always, but most of the time.
Well, and I've taught seminars before, though, where defense lawyers who do especially trucking defense work, and I've actually seen their contracts where they say they have to be at a scene of a wreck within so many hours, especially some of these bigger national truck defense firms, and they actually have to have either themselves or they have to have staff at a scene of a wreck. So sometimes I think they get hired quicker because they get then dispatch, semi-drivers in a wreck, calls dispatch sends an email to their lawyers, and then boom, they've got a team out there.
Yeah, emergency response teams that the bigger defense firms that handle the bigger litigated trucking cases, more serious accidents, higher limits, things like that. And usually, on site within 24 to 48 hours, very proactive in that circumstance. But I would say, 90 to 95% is more reactive because we're being notified of a car accident, a year and a half or 2 years later.
I know one of the things that have changed dramatically since I started practicing is what we do on the front end of a case. When I first started, there wasn't all the downloads that you couldn't go do downloads of cars. There wasn't, the scanning available, the 3D scanning. There was, I mean, you would hire maybe an investigator to go out to the scene of a wreck, take some photographs, maybe do some measurements. Maybe you did a crush analysis, but today it's completely different. I mean, when we get hired, I mean, it's like you start off immediately trying to preserve the evidence, sending preservation letters out, finding the vehicles, finding the police, getting the police report, scanning the scene. I mean, that is, at least from the plaintiff side, that's hugely different than when I first started. How about the defense side?
Yeah, I think the same is true, provided that you're given notice. If there's an inspection and say it's a total loss valuation and the vehicle's at IAA or somewhere and we have to go do an inspection, you've requested a download, then I get retained and we can get proactive rather than being reactive later. But, not to toot your horn, but you always do a good job with regard to pre-suit information, pre-suit investigation, doing the downloads, sending out the letters, the preservation letters and things like that. So we get more involved when we have a firm like you than probably, 90 to 95% of all other firms.
I mean, and it's kind of scary to me because we get hired sometimes by lawyers who have had a case and they don't do that front end. And then they try to settle it. And then when it doesn't settle, they call me and say, "Hey, Dave, would you help us out with this case?" And, I tell you what, and maybe it's just because we're getting spoiled, but it's so easy to preserve evidence. It's so easy to go out and scan. I mean, I had a semi case out in Missouri by Kansas City, and it was years ago. And I remember I had to hire a pilot to fly over the scene to take pictures do aerial photographs. Where now you go look at Google. You can send out a scan and do a scan of the scene. But back then, I was always very proactive, but I had to fly a plane over. And it turned out that intersection was changed. And had I not done that, I wouldn't have had a good aerial to be able to prove my case. It was a semi pulling out of a truck stop area, a rest stop. And so, I just been scared. I think I started doing that in the very beginning just because I was scared I would miss something. I would work with reconstructions like early in my career, and a reconstruction would say, "Did you measure this?" And I go, "Oops, no."
Yeah. What was the yaw, Mark? We tried to figure out what a yaw was.
Yeah, like why did you measure? And so now the great thing about it is if you go scan it, you have all the measurements forever. And maybe 75% of the time it doesn't matter, but at least that 25% of the time it does. So I would assume you do that on both sides.
Yeah, the same thing. And you see some drone technology in use too. So, I mean, that's really good especially for the environment as an issue and surrounding, the cornfields or whatever it would be that, led to it. That is really helpful. But the scanning is just phenomenal, what they can do now with the 3D scans and all of that.
Yeah, we did one in Newcastle with a semi, and I didn't realize there was a obstruction of view. I mean, it didn't look like it. And it turns out the defense raised an obstruction of view, but luckily we had scanned it and we were able to show that to the defense that it wasn't an issue. And it turned out to be, a non-issue, but it could have easily been an issue had we not scanned it.
It's like a farm field. When the corn's up, there's an obstruction. When the corn's down, it's not an obstruction. I go out and I look at a field and I see all kinds of corn and say, "Oh, no wonder you couldn't see." But you have to look at the circumstances on the date of the incident.
And again, I think so. Not everybody tries cases. So certainly on the plaintiff side, the side that I'm on, I know lawyers who have never gone to trial, who've told me that they've never gone to trial. They've either settled their cases or they refer their cases out, or they do some other type of law that doesn't require them to go to trial. I think on the defense side, that's probably different because you guys are hired to represent, litigate a case, and go to trial if you have to. So you guys end up, I think, with a lot more trial experience probably than the plaintiff side. So let's talk a little bit about trials because I don't think jurors understand what's involved. So first of all, does every case that gets filed, does it go to trial?
No, absolutely not. I would say 95% of all cases resolve either by way of settlement or by way of mediation. So the 5% that we're trying are issues with liability issues or severe damage issues.
And then the other thing clients always ask me when they hire me in the very beginning is how long does this process take?
Yeah, well, that kind of depends on the venue. So, typically we see a year and a half to bring it to trial. Could tweak out a little bit more. Marion County is always kind of the bellwether because we're closest to that, and they're really upping the trial dates. They're getting them set earlier, trying to be more proactive in their scheduling of everything. So, a year sometimes, but typically a year and a half because all the discovery has to be conducted.
So like in Indiana has a statute of limitations, so you don't have to file your lawsuit for 2 years.
Right.
Every state has a statute of limitation. It can vary a little bit depending on what state you're in. Missouri, for example, we're over there, it's 5 years. Um, but, but we don't tend to hold our cases. We tend to file our cases if they're bigger because while our clients are getting better, we'd rather work the case and give the defense what they need to value the case and move it along. So, but one of the things that we're limited by is if it's not a wrongful death case, but if it's an injury case or catastrophic injury, we kind of have to wait until the client gets better, or we know the client's as good as they're going to get.
Yeah, and I agree with that, but there's also things that you do that a lot of other firms don't do with regard to, again, being proactive on your case. Early filing means early discovery, which means you can go out, and you've done this on our cases. You go out and you depose the first responders, the police, the fire, the emergency personnel. I've had cases with you where you're taking 10, 12 depositions in the first few months because those people have a much better memory closer to the event than 2 years later when you pick up and they say, I really don't remember anything.
Absolutely. I mean, I can remember going down. I had a wrongful death semi case down in Kentucky, and I reserved a conference room for a week. And for a week, I just deposed every person that was at the scene, every firefighter, every paramedic, every police officer. And the reality was that, I would say 9 out of 10 of those people had nothing really to add. But there was always the one person who overheard a conversation, who saw something. And,
Right.
You never would know because you've got all this list of people on a catastrophic on I-65 fatality. I mean, it's just, there's all kinds of people there. There's different police departments. And sometimes I find the smaller police departments, sometimes they're not as active in the investigation. So they're standing around listening or talking to people. And so it's amazing to me how much information you can find. But like you're right, if you wait 2 years, first of all, those people may go away, but in addition, they probably don't remember much.
Right. And also, like during your investigation, I'm sure you've run into this where you're deposing first responders and then you find out that a trooper came on site and did an accident recon and it's not noted in the report anywhere. So if you're not early in that, you don't ask the right questions, I don't think you get the type of information that you can usually get.
Yeah, I know with us, so we always request the 911 calls. And then because the people who call 911 aren't listed necessarily on the police report. So they may see it, a wreck on I-65, and then they may just keep going rather than they don't want to get stuck there all day. And so those people a lot of times have a lot of information, but you don't get that unless we get the 911 calls. That I always hire a private investigator. Private investigator talks to every one of those people, everybody who calls 911. And again, 9 out of 10 may not have a whole lot to say, but that 1 out of 10 may be critical to your case.
Yeah. And, just by way of personal experience, I was heading downtown one time and I was on 70 and a truck merged and hit a car. He was trying to go from the middle lane to go north on 65. And I witnessed it and I called in, but it wasn't safe to stop. And about, 20, 25 minutes later, trooper calls me back and says, "Hey, were you a witness to this?" "Yes, sir, I was." "And what did you see?" I told him. He said, "Well, the truck driver's here and he's telling me that the car hit him." And I said, "Absolutely not." So, I mean, I think that 911 is very important, especially if they're an eyewitness and they can tell you what they saw.
Yeah. And the other thing that's kind of time sensitive to me, and one of the reasons we try to move quickly is, it's amazing how many wrecks now are caught on video. Either dash cams, like a lot of trucks have cameras, a lot of cars have cameras, police have cameras, they have body cameras, they have car cameras. There's like down in Tennessee and Indiana, all over the country, they've got cameras on the highways. In Tennessee, you can request those. You can actually watch them right away. Some states are harder to get, but the reality is there's so much on video. Businesses, I don't know how many times we've had different versions, and we'll go to a Speedway gas station.
Yeah, retailers, right? Yeah,
Yeah,
exactly.
and it's like, holy cow, or even DoorDash or door cameras on people's doors will catch it. It's amazing how, and a lot of those places don't keep that stuff very long, especially when they're not involved in litigation.
And I don't know if you just saw this, but Ring has just come out with a new procedure that they're not going to cooperate in investigations voluntarily.
Yeah.
Because they're getting a lot of feedback from privacy issues. So they're going to have to, you're going to have to request that information by way of subpoena or otherwise in order to get it from Ring now. But, so many times we see those dash cams or the retailer videos, where, I have a client and he says, I wasn't speeding. And then he's going, 70 miles an hour in a 35. And we see him zoom by a shell. So
Yeah.
that can be very,
And I've done that with adverse weather where the roads were bad and the driver at the time says he's not doing, excessive speed, but then we go back and find footage of him, flying. And other times we get stuff that's damaging our cases and our clients, but I would rather know that on the front end than find that out 2 years or a year and a half down the road.
yeah. And another thing is, just follow up with regard to the investigation done by the police officer. A lot of times witnesses are identified in there and, just making sure you call them and making sure what they said, because so many times you say, well, that's not what I told the officer, here's what I saw. And so just little things that we do on both sides, I think plaintiff and defense, but some do it better than others.
So so one of the things is that it's like, how do you determine value? Clients are always asking me, how do I determine the value of a case? And I don't. I mean, it's not like a crystal ball where I can turn it up and all of a sudden there's the answer. But how do you go about, as a defense lawyer, or doing the plaintiff side, how do you go about valuing cases?
So with regard to any valuation that's on a serious case, I think the less serious case, we kind of have if you get a soft tissue injury, we know how to evaluate those. But on a more serious case, what I do is I roundtable it with the other attorneys in my office, and I'll send them the facts. If liability is at issue, I might let them know. But typically, I just say, absent liability, here's the injuries, here's the billed medical, here's the Stanley, here's the ongoing nature of the complaints, the effects on the activities of daily living. And then I kind of let everybody respond, because there's some that are more liberal and there's some that are more conservative. So I just take that into account and, try to get a feeling. The more difficult ones, as you know, are the wrongful death or the quadriplegic, paraplegic cases, because maybe you haven't seen the life care plan and, the loss of earnings plan, and hard to evaluate until we get those type of materials.
How important is it for, like with the plaintiff, the injured party, how important it is for the plaintiff lawyer to get the defense lawyer and the insurance carrier the information? I mean, we try to update medical records regularly as we get them. We try to forward it to the defense, and it just seems to make sense to me, because if I was on the defense side, I would want to see the records, I would want to see the documentation. And I assume that's what everybody does, but how important is it for you to get that information?
If it's of utmost importance, because my adjuster cannot evaluate the case without bills and records. That's what he or she needs to evaluate the case. And if I don't have that, I can't take it into account. And so many times, both as a mediator and a defense attorney, I go in and the plaintiff has not provided supplementation, which just is devastating at a mediation, because we have to shut it down. Because it used to be, probably 10 years ago, adjusters could adjust on the fly. They get some additional information at mediation. They could handle it, bump the reserve, do things like that. Can't do that anymore. Everything is done prior to the mediation. We send out a notice 30 days before that says, if you have information, you must provide it to us within 2 weeks. If you provide it to us at mediation, it will not be considered, because no companies that I work for can adjust on the fly anymore, very rarely.
Well, and I think, if you're listening to this and you happen to have an injury claim with somebody, the one thing is that I hear a lot is like, why should we have to give them that? Especially on wrongful death cases. A wrongful death case, they're upset. You've lost a family member. It's a catastrophic situation to you, and it's just tough. And then I ask for prior medical records. And the reason I asked for it is that I want to provide it to the defense so they can see it to make sure that there wasn't a person to have a heart attack or a seizure or whatever. And so my thought process is, let's get this information, let's get it to the defense, and so if I have hospital records, if the person lives and they go to the hospital, let's get that stuff and give it to the defense so they can evaluate the case. But again, we do this day in and day out. But for the families, they're like, well, wait a minute. I mean, it's clear my husband or my wife died in this wreck. Why should we have to give them that? But I think in fairness, I mean, if I was in your shoes and someone lived and there was any question, I would want to see the medical records.
It completes the picture. You're going to show, here is Mr. So-and-so that died, and this is his family. And okay, well, what about Mr. So-and-so? I need to know, how was he health-wise? Was he disabled? Does he have a debilitating illness? I think that is all things that go into the evaluation, not only for me, but for the insurance company as well. So they have to have that prior medical history. And if you don't give it to them, it's difficult for them to evaluate. You go into litigation and I'm going to get it.
Yeah. And I think that I've even had cases where I had a lady, a mom, who was dying of cancer. And so she was coming back from her last vacation with her family. And a semi crosses the center line, kills her husband, and one of the two kids. Right. And so the family was like, they were concerned because she had cancer. And so again, we were very proactive. I said, no, the sooner I can get that to the defense, the better off we are, in my opinion, because she still died before she should have. And there is still value. But not giving that stuff to somebody and then having them find that out down the road is not doing anybody any good, not the plaintiff or the defense.
Yeah, but on my perspective, from a defense perspective, if I know she has cancer and it's terminal, then I'm going to be able to talk to a doctor and say, okay, this is what she has. How long is she going to live? And if it's 6 months or a year, then that severely limits the damages, at least in my opinion, with regard to the defense perspective, that would be recoverable if that person were to live another, 25 years with the injuries and permanency sustained in the subject motor vehicle accident.
And I would say that it increases the value of every day. So you and I would disagree on it, but the point is, I guess, is okay. What we should be doing is arguing about the impact, the effect, and not trying to not give information to each other.
Yeah, and I weight versus the ability to have that information. The more information that you can provide to me, that I can provide to my adjuster to evaluate the claim, the better off that you are. If we don't get things, it goes to litigation. I've got to go get them myself. I think that the real, we talked a little bit about trial and we talked about, what's going on, but I think the real issue on a defense perspective is what we call nuclear verdicts. And over the last, I would say, 15, 20 years, in reported cases over $1 million in trucking cases, the average verdict was $2.3 million. And within the last few years, it's gone up to $22.3 million, 1,000% increase, called nuclear verdicts. And we have to find a way from the defense perspective to get a hold of it. You like that. We do not. And I think that's why there is a very close scrutiny on very serious truck cases with regard to trying to get them resolved early, and probably less cases going to trial in the future, depending upon, again, the liability and the damage aspect of it.
Yeah, and I don't like the word nuclear verdicts, as you would imagine. There's a lot of legislation, a lot of misinformation out there by it. But I will say that, especially since COVID, I've seen jurors have been being fairer. I would consider fairer.
More money to the plaintiff. I understand what fair means to you.
But I think that certainly the verdicts have seemed to be on the higher side, I think, overall, than before. But I think if you look at those, like I look at the nuclear, what they call, defense calls nuclear verdicts, or the trucking industry calls nuclear verdicts, and I see, first of all, not all those cases are collected. So some of those verdicts, I just saw an Indiana verdict, which I won't talk about, but that, really wasn't tried. I mean, there wasn't a defense put up, and so because there's no insurance, there's no way to pay it. So sometimes I see verdicts like that. Sometimes I see ones that are set aside or reduced. And then sometimes, and some of the ones that are really quoted, when you actually go back and pull the transcript or look at those trials, they're horrendous cases where there was a trucking company that had 5 horrible fatalities in a really short period of time, or the driver's high on drugs, and goes out and kills a bunch of people. And so, you're going to see, if there's insurance coverage or if there's assets available, I think you're going to see high verdicts on those type of cases. Quite frankly, the best way to reduce big verdicts is, number one, run a safe trucking company. You run a safe trucking company that you hire good drivers, reputable drivers. A lot of the reputable trucking companies aren't necessarily the ones that they're not getting hit with the big giant verdicts. A lot of times it's the smaller kind of fly-by-night companies.
Well, there's a reason for that, though. So the bigger companies can pay better. And there is a shortage of truckers. There's anticipated that there will be 160,000 less truckers in 2030 than right now. And they just don't have people to draw from. So what is happening is the smaller people that can pay less have less experienced drivers, younger drivers, and that leads, typically to accidents.
Yeah, I find that the safe trucking companies are getting safer. They're getting better equipment. They've got better technology. They're monitoring in real time the drivers. They can monitor, like, are they sleepy? Are they, how are they doing? And the worst trucking companies are getting worse. And because, and unfortunately, I have cases where you have situations where we have what's called a chameleon carrier. So you have a trucking company that's really bad, and they can't get insurance. The federal government's going to put them out of business. And then what they do is they change their name.
Right.
And then they go out and I had one down in North Vernon where they killed 2 people. And this company could not get insurance. So the insurance company actually helped them. They changed their name, told them what they needed to do, and they then carried the minimum insurance, which under the Federal Motor Carrier Safety Regulations is $750,000. And they got minimum coverage. They had the same crappy equipment. They had the same bad drivers. And so they had one new driver. He's out driving for them. His equipment was so bad, he pulled it off the side of the road and said, "I'm not driving this. My brakes are not working. I'm done." And the owner of the company said, "Hey, get back in the truck and drive." The guy says, "I'm not driving it." And the owner said, "Well, then you sit there until I get there." The owner drives over, gets in that truck, drives it, brakes don't work, and he kills 2 people.
Yeah.
Now, those kind of cases drive the value, because it's horrible. It's terrible facts. There's no person going to listen to that and say that is a good fact. Yeah. On the other hand, a good trucking company would never be in that position.
Yeah, but what that bad trucking company does is now flip it to another LLC, open another company, put everything in there and move everything and, try to get that insured. But what happens in that situation is that company still had insurance at the time of that loss. So say it's $1 million, say it's $2 million, whoever insures that risk is going to have to pay that. And when they pay that, premiums increase. And then, when premiums increase, trucking prices increase, everything goes up. So,
yeah, I keep looking at the insurance companies still seem to be making a lot of money. I look at their financial statements and I don't see a correlation. I think, the bad companies carry minimum. They carry $750. The only companies I've ever put out of business, one in Iowa and one in Indiana, both were just fly-by-night outfits that had nothing. Their equipment was leveraged. I mean, they just had nothing. And so we're not seeing it. I do still say, I mean, it's a tough business. It's tough. I mean, truck drivers work hard to make a living, and they keep everything, they keep all the supplies coming to our stores, our offices. And so I respect truckers, and I honestly believe the majority of truckers are really caring, safe drivers. And I think the majority of trucking companies are good businesses. It's just, unfortunately, the bad ones can cause a lot of damage because they're driving 40 tons.
Yeah, and I agree with that. And I think what's going to happen if you look at the outlook for 2024, tonnage is supposed to go up 30%. So we've got to find drivers to drive that. And again, you have a shortage. You're going to have good companies that do a good job that, I've literally gone to a mom and pop trucking company, and their record keeping was in boxes below a shelf that they just threw, and I literally had to pick it all out. I mean, it's with what they can do today with electronic record keeping, watching the drivers, everything, it's just cost prohibitive with regard to a lesser trucking company.
Well, and I think that's probably true with a lot of businesses. I mean, you have to figure a way to run your businesses in a economical manner, and we see mergers and big companies merging, and I think there's a lot of issues out there. I'm against lifting the speed limits for truckers. I mean, a lot of wrecks happen at high speeds. There's just, one of the things right now is that truck drivers have no place to pull over. They don't have enough rest stops or parking spots, and they're only allowed to drive so many hours. Or if in adverse weather, they're supposed to get off the roads, if it's icy. But a lot of times they have no place to park. I know I think their legislature just agreed to put some more money into it.
Right.
But across the country, that's a problem where these truckers, like, where do they pull off? And if they pull off the side of the road, they're a danger to the rest of us.
Right.
So there are definitely things in the industry that are challenging, but hiring the right drivers, drug testing, having safety committees, policies in your company to make sure that your company is safe. There's a lot of things that can be done that will help keep verdicts down, and that's fine with me because we got other areas that we can practice in.
Yeah, maintenance of vehicles, vetting of all drivers, tracking technologies, everything like that can be used to be safer on the road.
Yeah, and then like you said before, the education of the drivers, so that now the drivers go through driver school. And I represent a lot of semi drivers who get hit by other semi drivers, and they tell me the quality of the drivers have gone downhill because there are some trucking companies that just want to push people through to get their CDL and get them in a truck, and they have no experience, or very little experience actually on the road.
Yeah, and like I talked about before, younger, less experienced. We're also seeing a lot of foreign drivers, and that can be difficult for the defense because a lot of times, when somebody hires you, David, you know where they are, or at least you think you do, and you can get a hold of them. I get a case where I've had a driver and he no longer works for a company. It was a couple of years ago. Sometimes it's difficult to find those people, and I have had several that have gone back to India or other countries, and I just have no contact with them whatsoever. So,
yeah, I think that's one of the. Go ahead. I'm sorry.
I was going to say a lot of times when a driver has moved on from a company, he really doesn't want to participate in litigation. So it makes those tasks much more difficult on the defense side.
Well, I'm seeing more foreign drivers. I had a case up in northern Indiana where a semi lost its trailer as it was pulling out of a facility. It got loaded, pulling out, turning left, and the trailer just comes disconnected from the fifth wheel. And then it loses all power, electricity when it gets disconnected. Unfortunately, my client's coming down the road at night, and he runs into the trailer and gets hurt severely. But when I deposed the driver, I had to go down in Texas along the Mexican border. The driver was from Mexico, and so the challenge was that he had not driven in cold weather. He had not maintained equipment in cold weather. He had learned how to drive in warm weather, maintain equipment in warm weather. And so here he was delivering auto parts to Indiana, and the equipment it turned out he was using the wrong grease on the fifth wheel, and it just came disconnected. And so it's like, that training, even if and he did go through driver school in Mexico, got his CDL, which then he was able to get a United States CDL. He had an equivalent in Mexico. But that's just because you have that CDL doesn't mean you're qualified to drive.
Right. But so many times you see employers that say, what do you want me to do? He had a CDL. I mean, he's qualified to operate a, tractor trailer. So they're willing to hire them, especially if they have a limited cost that they can spend on a driver.
So what's the biggest challenge for you as a defense lawyer when you have one of these big trucking cases or a big catastrophic case? What's the biggest challenge for you?
Just all the information that needs to be gathered is gathered in a timely fashion. Well, we talked about that earlier, but it's really absolutely necessary that we get out to the vehicle, inspect, download, photograph, everything that needs to be done, witnesses, logs, get all of make sure we have all the record keeping necessary. We can usually anticipate what we're going to need through litigation process. So we make sure that we protect that all the things that you put in your protection letter that you send to me all the time.
Yeah. And I would assume that on bigger cases, so I tried a case over in Wayne County, I think, Fayette County, and the defense lawyer had his hands tied. The insurance company would not allow him to try the case the way he wanted to try it, which I found out after the trial. So the insurance company is a TAP. They don't let him admit fault when it should admit a fault, but argue causation, that the TAP didn't cause the injury, but they don't let him. So they make him argue liability. We get a direct verdict. Then we go to closing on the damages. Jury pops him big. And then the insurance company comes and took all his files and fires him. And so firm had been doing this work for this company for years. And I saw him later at an open house at my Richmond office. And he came in and said that was the best day that ever happened to him because he was tired of the insurance companies telling him what to do and not letting him try cases. And I, quite frankly, he would have beat me had he been able to try the case the way he wanted to try it. So I see that on smaller cases. I don't see that on bigger cases. I see the lawyer being very involved in the strategy and involved in how it does. That's accurate?
Yeah, I think that's absolutely accurate. And I think the adjusters are more skilled that handle those type of claims. They're more willing to, spend defense dollars to make sure that all the information is thoroughly investigated, dot the I's, cross the T's, do everything necessary on a trucking case. I see that much more so than on a minimal automobile accident.
And I think from my perspective, I enjoy when I have these bigger cases. Quite frankly, the quality of the lawyers on the defense are better. I get to go against you, and you're an extraordinarily good lawyer. I get to go with other defense lawyers that are extraordinarily good lawyers. And I don't mind that. I actually enjoy that better because you're dealing with people with experience and we will disagree. But at the same time, there's a mutual respect typically. And you see what everybody's doing. Everybody's working the case. There's not this pettiness that sometimes happens in some of the younger attorneys that don't have any experience. You fight over little things that have no meaning. But I quite frankly like going up against you and the other defense bar that handles these cases.
Yeah, and I think that's absolutely true. And you've seen it when, you have a supervising attorney at a bigger firm and some young guns come on and they want to try to prove their worth. And then you're, fighting unnecessary fights. But fight the battles when you need to fight them. Not everything has to be a battle. It's called civil litigation. And I've done seminars on this, and you just try to remain civil. David, you and I do disagree on a lot of things, but I still, respect you at the end of the day. I still consider you a person that I know, a friend. But, when we're going to head, it's like a basketball game. I want to win. There's no holding back. I'm going to play as hard as I can. But you can do that civilly and not have all the heated information, association, all of that happens quite often.
Yeah, and I think the one thing that we all have to remember is that you and I are both very competitive, but I always encourage all my young attorneys that work for us to remember that it's not about us. There's times when I really would like to go to trial because I know I have a great case and I know we're going to really get a giant verdict and we're going to win. And that competitiveness is there. But my client looks at me and says, I don't want to. It's about my clients. It's about our clients. It's about your insurance carrier. Your times there's probably cases where you wanted to try and they decided to settle. And so, or maybe he had to go try it and you would have preferred to settle. But the same thing with us when we represent families is that I don't ever force my clients to go to trial. I don't force my clients to settle. If they want to go to trial, I'm happy to go to trial. If they want to settle, then I'm happy to go to settle because it's not about me. But sometimes that is in the heat of battle. Sometimes that's a little challenging because you do want to win.
Right. But, in fairness to you, we have mediated a lot of cases with you as the plaintiff's attorney and myself as a defense attorney. And you have been very honest with me that says, I think the case is worth this amount, and we don't offer that amount, but that you leave it up to your client to make that decision. And it's their decision to make. But what you see so many times is that plaintiff's attorneys will get a good offer on a case. Their client wants more and they don't want to try that case. So that a lot of times they'll end up sending it to you or, just, discharging the client because they don't want to go forth with everything that needs to be done for trial purposes.
Well, and I've been in mediations. I'm sure I've been in mediations with multiple where there's multiple plaintiffs, multiple people injured, different lawyers. And I've, quite frankly, I've never been a mediator. I went through the mediation training, but I don't think I have it in me. I give you credit for that and all the mediators. But I've sat there with other plaintiff lawyers and two things shocked me. One was that they didn't know really what their liens were. They didn't know what they had to pay back. And two was that they were asking the mediator to really push settlement on their client because they did not want to go try the case. And I can't imagine not going into a mediation, knowing all the facts there are, or at least doing everything I can do to learn the facts, whether it's a lien, medical bills, all that. But in addition, not leaving it up to the client and letting them make that decision.
Yeah. And there's another attorney, and she'll say for trial, the most essential thing is to prepare. For mediation, the most essential thing is to prepare. I mean, you have to know what your bills are. You have to know what your expenses are. You have to know what reductions can be taken. How else can you give an informed information to your client for them to make a decision? Because, at the end of the day, you've been a mediator for a long time. At the end of the day, the plaintiff wants to know, okay, after attorney fees, after expenses, after payback of my bills, what am I going to get? And that's what they want to know. So I think it's imperative that you have that information for purposes of mediation.
If both sides have the information and all the information available to them and they go into a mediation, do you find that as a mediator, obviously there may be a little bit of difference in the value, but is there a range? Do you feel like both lawyers are within a range usually?
Yeah, so as a mediator, I've been doing this again for 35 years. I get to practice a little bit on the plaintiff, but more so on the defense. So I always look at a case and I evaluate it, and then I kind of look where everybody else is. And sometimes everybody's within shouting distance, and other times plaintiff's real high or defense is real low. And then I know where my focus has to be as a mediator to try and say, hey, I've evaluated this. Sometimes you just get an early sense early on what parties are looking for, and you try to work toward a common goal. And sometimes it's just it's not going to settle. I mean, you just have a feeling right away, or you get a sense right away that the plaintiff's expectations are way too high, and I can't manage them or help to manage those. The defense is just not offering any money because they think that there's a tremendous liability. But as a mediator, just trying to find some common ground.
So I have the utmost respect for you as an attorney, as a person. You do litigation. You've built a very successful law firm that's headquartered up in Noblesville. You're teaching, you're mediating, you're doing some arbitrations. So out of all the stuff you're doing, what do you enjoy doing the most?
Well, I think I'm getting a little bit older, so I think I enjoy the mediation. I'm unlike you. You say you can't see yourself doing it. I can see myself doing it. I really enjoy it because it's just trying to find a unique way to get a case settled. I mean, anybody can carry a number. Oh, $10,000 at demand. Oh, $1,000. But what's the substance of that? What is important in this case? And what I learned really early on is that you have to keep the plaintiff involved. Because one case I went back and forth and I ended up settling the case, or well, so I thought. I got a $25,000 offer on it, and I thought that was great, and I took it in, and the whole time that we've been negotiating for 3 hours, the plaintiff's been sitting right there listening. And so I brought back the $25,000, and the guy looks at me, he goes, "Oh, no. I want $25,000. So, I mean, even though he was there for 3 hours, doesn't mean that there's necessarily involved. So you really have to keep the plaintiff involved, find out what their expectations are, because a lot of times as a mediator, they'll tell you, I do not want to go to trial. I want to settle this case. Like they tell you, they'll tell you that, and you know that you want to get it done and maximize the recovery to your client. But some people are dug in, set in their ways, and they want to be righted and they want their day in court. So you have to just read the rooms properly when you're doing the mediation.
Well, this is the podcast After the Crash. Is there anything else that you would like to add that we haven't talked about, or any areas you want to talk about we haven't talked about?
No, I appreciate the opportunity. I think it's going to be an interesting 2024. Again, increased tonnage, inexperienced drivers. I think you're going to see even more litigation in the trucking industry.
This is David Craig, and you've been listening to After the Crash. If you'd like more information about me or my law firm, please go to our website, ckflaw.com. Or if you'd like to talk to me, you can call 1-800-ASK-DAVID. If you would like a guide on what to do after a truck wreck, then pick up my book, Semi-Truck Wreck, a guide for victims and their families, which is available on Amazon, or you can download it for free on our website, ckflaw.com.